Now, Chinese state-owned enterprises, privileges or immunity is the title of our talk this evening. Forming the backdrop of this talk will be a decision which many of us have at the back of our minds or have heard about. TNB Fuel Services versus China National Coal Group Corporation, I would say, had its first act played out in our courts in 2013. Now, this case culminated in the Court of Appeal decision reported in the 2013 MLJ 4th volume and has been referred to by our courts practicing arbitration on numerous occasions now. It stands for two important propositions. The first being, it clarified what it means, the incorporation of a binding arbitration agreement by reference, that is Section 9(5) of the Arbitration Act 2005. And the second one, though obiter, the Court of Appeal endorsed the fact that a tribunal properly constituted was competent to decide its own jurisdiction. That is competence. That's the first time I think that issue came up in our courts, and that is under Section 18 of the Arbitration Act 2005. The arbitral tribunal has jurisdiction to determine. These are the two propositions of law that has been established by the first act that was here. Subsequent to that, this case went on for full arbitration. Arbitral award was issued in favor of TNB Fuel Services. Then they attempted to have that award enforced against assets of China Coal, National Coal Group of Companies, assets that were located in Hong Kong. And that's where this decision that we are talking about will be addressed to by our eminent and distinguished speaker, Ms. Teresa Cheng. Now, this award, this decision of the Hong Kong Court of First Instance was only issued on the 8th of June this year, and it has far-reaching implications, not just for people who have arbitration clauses or contracts with Chinese state-owned enterprises, but I think generally as far as how immunity or crown privileges can be addressed whenever there are issues of enforcement or court proceedings related to enterprises of this nature. I'm not going to go into that area. Ms. Teresa Cheng will do the honors this evening, crown immunity, state immunity, and so on. Now, my first contact with Ms. Teresa Cheng was many, many, many years ago, many moons ago, if you would say. This was when the Hong Kong airport, at that time new, was being constructed. And I think one of the, like always, she shared her experience with us when on one of her many trips down to Malaysia, and she said that contract had a clause for a adjudication board right through the contract. It was provided for in the contract itself, and that was smooth. It enabled the disputes between the parties to be resolved right from the beginning to the end without waiting for the arbitration or issues to be raised at the end of the contract or project. So that was my first. But if you look at the CV that you have, that's not all. I would not go to read out that to you. I would just say this. She's an eminent senior counsel, a jurist, a chartered arbitrator, a chartered engineer. She qualified as an engineer first, then became arbitrator, and did first engineer, then lawyer. And she has excelled herself not only in Hong Kong, but all over this area, Southeast Asia, Asia, and internationally. This afternoon, someone was telling me, Mr. Chong was telling me, she is the first non-white or first Asian to be the chairman or president of the Chartered Institute of Arbitrators. I think it's a big honor. And she has acted as counsel, arbitrator, and also as teacher. She's a professor. And she has also led all these various institutions, arbitral institutions, locally in Hong Kong, in Asia, and internationally. And she has contributed to shaping policies and also government input into what should be the outcome of various matters, legislation, and so on. Now, I will only read a very short part of her CV, which will give you a glimpse or of what we are going to benefit from. You know, she has been appointed on various important positions. She's the Executive Council member. This is only the current one. She has been passed as well, but these are only the current ones. She is the Executive Council member of the Asian Academy of International Law, panel arbitrator of the International Center for Settlement of Investment Disputes, chairman of ICSID Administrative Council, external international finance cooperation, alternate member on the World Bank Sanctions Board, council member of China International Economic and Trade Arbitration Committee, panel arbitrator of the Court of Arbitration for Sports. Her field is just not construction law, includes sports as well, and so on. And on the academic front, she is now course director of the International Arbitration and Dispute Settlement Program School of Law, Tsinghua University, a visiting professor of the School of Law of the Tsinghua University, Beijing, and adjunct professor at the Hong Kong Polytechnic Universities. Now, one of the outstanding things about Ms. Teresa Cheng is this. Whenever she comes around this area, she is ever willing to share her expertise and experience, her insights into recent developments of the law in the field of construction arbitration, and so on. And I believe when our branch here requested her to share her views on this very recent decision, she willingly agreed, and we have her with us. We are honored, privileged to have you, Ms. Cheng, with us, and I will not say anything further. She will take off from here, but let's give her a warm welcome.
Thank you very much, Dato, for that introduction. It is, in fact, my privilege to be able to talk about this very hot topic of the latest development in Hong Kong, which, of course, has so much link with what is in Malaysia. I hadn't realized that in Malaysia, before the arbitration start, it already established some important principles in the arbitration field here. So I only go in, as I will tell you, in a very narrow angle, but I think it turned out to be an important angle, I think, in the context, in particular, also in business angle as well. So I'm very privileged, and I have a very high hurdle to meet, because I am keeping you away from the sunny afternoon or sunny evening, and on a Saturday. So I hope what I'm going to say to you will be worth you giving up your Saturday evening enjoyment. What I'm going to do is this. There are a number of things that I would like to share with you, and I would try and not be too long, so that there are chances for you to share views. It's important for interactions and exchanges. What I will try and look at with you is what exactly is a state-owned enterprise, a Chinese state-owned enterprise, not a general one, and whether it is a state, whether it's equivalent to China. I would then also look together with you as a state-owned enterprise and another type of institutions in China called public institutions, or in Chinese called 事业单位, because that is both rather confusing to a number of people. And I had the great benefit and privilege of doing both of these cases that were looked at in Hong Kong in the context of Crown immunity. I will also just very briefly highlight the difference, I'm sure you will all be familiar, of sovereign immunity or state immunity as it is sometimes called, and Crown immunity, which is a common law concept. And then to look at the case, and then ultimately to share with you 3 statements that have been made by the People's Republic of China that will allow you to understand where China's position is, at least the public position that has been propounded on the position of state-owned enterprise, and then ultimately perhaps open to questions that you may wish to make. Now, the very first question is, what is a state-owned enterprise? Under the laws of China, it is set up as a separate legal entity. But then there is always the concern that it is actually the assets of a state-owned enterprise belongs to SASEC, S-A-S-E-C, the state-owned state assets corporation, SASEC. And that particular element of state-owned enterprises always allow people to think, well, in fact, Chinese state-owned enterprise is the state, and therefore it would be difficult to sue them, and they might claim all sorts of immunities, and therefore as a business, I perhaps should not be dealing with them, or if I deal with them, how should I protect my interests? So is the state-owned enterprise part of the state of the People's Republic of China? A question that will have to be looked at. And the state-owned enterprise in China is not very formally legally defined. There are 3 types of corporations which we would describe as state-owned enterprise. One would be wholly state-owned enterprises, and that is 100% owned by the state, owned meaning as shareholders. They call it contributor, but as I will illustrate to you, they are in the form of shareholders. Another type is called state-controlled enterprises, and they are more than 51% shareholding interest, more than or equal to 51% shareholding interest, or with the most significant interest being controlled, by the state. And then there is a third type called state-participated enterprises. They are still, no matter how they're structured, they fall within the broader category that we call state-owned enterprises. So the very first question is, and this will be answered when we look through, when I take you through the TNB versus China National Coal case, which you will conclude, I hope, together with me, as the judge has, that a state-owned enterprise is not part of the state of China. So it is not state per se. And therefore, with that sort of background, it will then bring into the situation, or it will bring into mind 2 concepts that would be relevant to a state. One, as I said, is state immunity. When it's state immunity, it would be something that would be applicable to foreign courts. It goes into the basic principles of international law, that all states are equal, and no state court would have jurisdiction over another state. And then there is the question of exception to the absolute immunity. We call this absolute immunity. This is where international law begins. And then there is then the exceptions that are created for commercial activities that are partaken by states. And in those situations, some people have been calling that restrictive immunity, but I prefer to call it a commercial exception. And that looks into whether the acts of the states involved in that particular activity is an act of state or a commercial activity, or in the terms that I used, whether it is iure imperare or iure gestione. So that will classify whether the commercial exception applies in the national law. So I'm not sure about the Foreign State Immunity Act in Malaysia, but if there is one such act, then the consideration of whether the particular activity is iure gestione will allow the court to decide whether the court has jurisdiction over another foreign state by reason of this commercial exception. In terms of state immunity, there is also the concept of immunity from suit and immunity from execution. And immunity from suit is whether you can actually sue them, and immunity from execution is whether you can seize the assets of the states. Now, there is a pool of different views. There is a view to say that in terms of immunity from suit, the commercial exception generally apply because there was a UN convention that have been concluded, although not ratified enough for it to be effective yet. But then insofar as immunity from execution is concerned, the majority view and the better view would still be that it is an absolute immunity. In other words, seizing the assets of the states are going to be relatively difficult. And that's why, in terms of planning the commercial activities, one has to bear those things in mind, and you might have to think about bonds in advance, etc. So that is state immunity. Insofar as Hong Kong is concerned, being a common law jurisdiction, there is another concept which is called crown immunity. And I will illustrate to you what that is. In gist, it is this: the domestic court cannot have jurisdiction over its own government unless it is precluded or exempted by legislation, such as the Crown Proceeding Acts in England, or in Hong Kong, the Crown Proceedings Ordinance in Hong Kong. So that principle will then mean that Hong Kong courts, being a Chinese court, will not have jurisdiction over Central People's Government. It has jurisdiction over Hong Kong government because the Crown Proceedings Ordinance say Hong Kong government will be subject to the Hong Kong courts. But whether it has jurisdiction over the Central People's Government was the question that was raised. And as I will illustrate to you, the conclusions based on the common law development has been that even before 1997, before Hong Kong reunifies with China, Crown immunity exists. In other words, prior to 1997, Hong Kong courts would not have jurisdiction over the British Crown in the UK. So that was the conclusion that was drawn. So that's the Crown immunity aspects. So this would be something, as I said, by way of background for you to be aware. So sovereign immunity looked at in foreign courts, and Crown immunity only in Hong Kong courts. The next thing to consider, as I have said, is that there is another type of entity in China called 事业单位, institutional organizations, public institutions. There are a number of terminologies or interpretations. Now, the institutional organizations, this type of 事业单位, was considered in a case before the TNB case, also on the case of Crown immunity. And that causes a lot of misunderstanding, thinking that, oh, state-owned enterprises cannot be sued in Hong Kong. So I was very glad with the TNB case to clarify the position. State-owned enterprises can be sued in Hong Kong. They enjoy no immunity in Hong Kong. But 事业单位, which is the public institution, enjoys immunity because it is part of the government. Now, let me just explain a little bit about how that particular 事业单位, in the case called Hua Tianlong, was arose. The Guangdong Salvage Corporation, that was under the Ministry of Transport or Ministry of Communication, as was described in the case. In Chinese is 交通部, which controls all the shipping and all the rest of it. So under the Ministry of Transportation or Communication, as was interpreted, there are then provincial equivalent. Under the Guangdong Provincial, there is then a Guangzhou particular entity that was set up. It is still part of the chain of the government, and that small entity called the Guangdong Salvage board was then the subject of the entity that enter into a commercial contract. The question in the case of Hua Tianlong is whether that body, which is a 事业单位, is entitled to immunity, and the courts say yes, because it is part of the government. State-owned enterprise is not part of the government. A 事业单位 is part of a government. What are 事业单位? It is, you really have, these bodies, these entities know who they are. They know that they are 事业单位 because there are certain regulations that govern their operation, both within the ministry but also in their activities, such as they have to report up in terms of financing, the whole management has to be controlled, and they really have very limited freedom of autonomy in conducting business. But this type of 事业单位 also has a business registration certificate, and that was the reason why in the Hua Tianlong case that became an issue. So they say this is a business entity, it has a business registration, and therefore you cannot enjoy immunity. That business registration is not going to change the very nature of a 事业单位. So for example, in the arbitration community, I could use, for example, CIArb. We all know. CIArb is a 事业单位. So it is still part of the Central People's Government. There are other institutions or bodies that have been set up that can do business that are also 事业单位. So in other words, when you are conducting business with a Chinese entity that you think has some government relationship, you want to ascertain and make clear whether it is or is not a 事业单位. Because if it is a 事业单位, it is part of a ministry. If it is part of a ministry, it will enjoy state immunity because it is part of the government. So you will want to make sure and deal with that in your contract. In a very broad term, the 事业单位, these public institutions, would be different from a state-owned enterprises in a number of different aspects. One, the 事业单位 would be established for a public purpose, primarily public purpose, but with an ancillary power to conduct commercial transactions so that they can then maybe subsidize whatever public function that they are doing. Secondly, this type of 事业单位 would not be allowed to carry on business without government consent, without the ministry or the provincial government's, provincial ministry's consent. So you see the control being there. Thirdly, the finance is entirely supported or assisted by the government or the relevant ministry. So again, financial control is not autonomous. Fourthly, the assets that is allocated to that particular 事业单位 must be used for very specified purposes. So they cannot develop a new business, for example. There is a specified purpose by which those assets are to be used. Fifthly, there is no autonomy in managing the assets allocated. Everything you have to get approval. And lastly, there is no autonomy to dispose of the assets that may be merged with the previous one. You cannot manage the assets in any way you want, and you definitely cannot dispose of the assets without the authority of the relevant ministry that is controlling this particular 事业单位. So the difference with that compared to a normal corporation, normal entity, normal company, you can immediately see the difference. Now, I do not know whether Malaysia, for example, have these type of bodies that have been set up, but I try and equate that, and this, it has not been tested, I may be wrong, but it is like in Hong Kong we have entities called trading funds, which are set up. It is within the part of the government, but it is set up as a trading fund so that they are a separate accounting entity, independent accounting entity, but the funding and all the rest of it is still controlled to a certain extent by the financial secretary, for example. And so these probably would be the equivalent of a 事业单位 if one is to compare that. So that is the difference between a 事业单位 and a state-owned enterprise, and they are different, as these two cases that I'm going to take you to will show. The first case is the case of Hua Tianlong. In very rough terms, the case of Hua Tianlong involves certain contracts with the Guangzhou Salvage Board, GEZC, I think it's exactly called, I forgot the exact name, and Guangzhou Salvage Bureau. And this particular GSB is a 事业单位, having the very entity features that I've said. And these features, I hasten to add, is not checked by de facto mean. It is de jure. In other words, there are laws and regulations that sets out those elements that I have highlighted. The test is a de jure test, not a de facto test. So these are the 事业单位 elements. So in that particular case, GSB entered into a contract with another company, and there were some breaches and some disputes, and the vessel that is named, named to be used in that particular contract, which is Hua Tianlong, passed through Hong Kong waters. In fact, it went into Hong Kong waters in order to salvage one of the sinking ships in the Hong Kong waters. As soon as the salvage was done, there was a warrant of arrest, the vessel was arrested, and then there is this whole series of litigation. I was brought in relatively late, and that is why, in that case, if you look at the Hua Tianlong number 3 case, the case, I win on the argument, but the case lost on the waiver. The Crown immunity was established, but it was found to be waived because a number of events have taken place. So it lost on the waiver point. But in that particular case, we argued, I was instructed to act on behalf of the Guangzhou Salvage Bureau, the GSB, the 事业单位, and we established that it is entitled to Crown immunity. Now, some of the passages that is relevant in that particular case was actually quoted in the TNB and China National Coal case, because in that particular case, the very same concept of Crown immunity was being revisited. So I let you look at some, I'll take you to some of the basic relevant passages, if I can just read that out. First of all, the courts in the TNB case, citing the Hua Tianlong case, confirmed and followed that the Crown immunity exists and continued to exist as a matter of common law, because after 1997 we maintained the common law position, so whatever common law that exists before 1997 continues. So the examination in the Hua Tianlong was whether Hong Kong court has jurisdiction over the British Crown in the UK. The answer was no, and therefore it continues. The Crown, instead of the British Crown, it became the CPG, the Central People's Government of China's Crown. So in that sense it is quote-unquote Crown, but effectively it is the immunity in that sense. So when the case was being looked at in Hua Tianlong, the court recognized, and we all know that the Crown immunity concept started from the principle of the king can do no wrong in the old days, in the good old days. We traced back, when I did the case, we traced back to right where it began, and it shows that from there it moved on to the parliament, etc., etc. So those to the government is well established. Then the more interesting development is the meaning of crown was found to be extended from the persons of the king or sovereign to a body corporate established by the executive arm of the crown. So that has gradually moved there. The consequential, upon this extension of this meaning of the word crown, the issue arose as to how to define whether a body corporate was or was not part of the quote-unquote crown. So that was how the court looked at that. And in Hua Tianlong, Judge Stone said, for my part, I agree with the contention that when assessing whether a corporation can be said to be part of the crown at common law, the material consideration is the control which the crown has over that corporation, albeit the objects and function of that corporation also go into the evaluative mix. In terms of control, I further agree that the salient question to be asked is whether the corporation in question is able to exercise independent powers of its own, which was the very point I mentioned to you just now about 事业单位. So having found Crown immunity as a matter of common law exists, having found that in the particular case GSB is actually a 事业单位 with no autonomy or very limited autonomy, and applying the control test, because there was a room for argument as to whether it is a function test or a control test. The court preferred the control test. The court concluded that on that basis GSB was entitled to Crown immunity, and therefore the claimant cannot pursue the claim against the GSB, and the vessel would then have to be released, subject to waiver, and the court found the numerous acts that have been done amounted to waiver. Now, waiver is an important point. Waiver arises if there is knowledge of the person who can waive. The person who can waive is not GSB. It is the Ministry of Communication or Ministry of Transport. And the court finds that with all these things that's happening, it is clear that the head knows that they could claim immunity, but they waived it, and therefore the court has jurisdiction. So that was the situation of the Hua Tianlong case. Now, in that case, I was acting for GSB, as I said, and we are saying they are 事业单位 entitled to Crown immunity. The other side was saying, no, it is not. It is really a state-owned enterprise, and therefore a state-owned enterprise does not enjoy immunity. Now, we never dispute in the Hua Tianlong case that state-owned enterprise would enjoy immunity. The issue was whether or not it is a 事业单位 or a state-owned enterprise. And that, I think, is where a lot of people, when they read the case, perhaps cursorily, did not realize, and sometimes misquoted that in a number of things that I see have been quoted by, with respect to some of the law firms' reports, case reports and updates. So that, with respect, is wrong. So that case was clearly just 事业单位 establishing Crown immunity and joint immunity, no immunity, no jurisdiction over the 事业单位. So that created a lot of uncertainty. People weren't sure, because people don't know enough about the difference between 事业单位 and state-owned enterprise generally. And so if you can go on to the ICA, the International Council for Commercial Arbitration website, I've put up an article to explain that, and I sort of literally set out that state-owned enterprise is not covered by all this. Those were my opinion at the time, and now it is confirmed, fortunately, to be law by the case that I'm coming to, which is the TNB and the China National Coal case. So this case arose from, as Dato has explained, the enforcement of an arbitral award. When that award was sought to be enforced, it obtained ex parte recognition by the court, converting it into a court judgment. A charging order nisi was made, and then at the time when the charging order nisi was being sought to be made absolute, the China National Coal raised the question of immunity and say, I am part of the government, and therefore I am, like Hua Tianlong, enjoying immunity. China National Coal then wrote to the Secretary for Justice and asked the Secretary for Justice to intervene. So the Secretary of Justice instructed me to intervene. And as an intervener, as you will all know, we're not concerned with the results. We're concerned with what is the right law. All right, my opinion has already, if they had looked hard enough, been on the web, publicly available, that in my view, state-owned enterprise would never enjoy immunity, or would, so I should not use the word never, would not enjoy immunity except in certain circumstances where they are carrying out acts of state. Arguably, that might still enjoy immunity. But generally, when they are building a road, constructing or buying and selling coal, as in this particular case, my personal view at the time was that they won't. So, as I said, this is in the public domain already. People should know about it. But anyway, I was instructed, I gave my opinion, and the SJ decided to intervene. We were allowed to intervene. So I, and with Adrian Lai, my junior, we went in and did the case. And Adrian Lai, my junior, were the very same counsel who did the Hua Tianlong case, who say that GSB had immunity. So probably most people would think, oh, they're going to argue immunity again. But the law is not that, as the court now, thankfully and rightly, in my view, accepts. So we went in and argued the case, and in the particular case involved, the Malaysian company was, of course, arguing there is no immunity in any event, and then arguing there is waiver. The China National Court was saying, yes, they have immunity, look at Hua Tianlong, and we go in and say, neither of you are absolutely correct, because you have not asked the right question. Because even the Malaysian company, when they go in and argue, they haven't seen the distinction between a 事业单位 and a state-owned enterprise. And so we say that the Hua Tianlong is clearly distinguishable from the case on facts here. And therefore, we bring to them the relevant law and establish that it does not have immunity. Now, how does the court go about it? The very first question we ask the court to ask is, who can assert immunity? Very briefly, state immunity is a given in a way. You don't really have to assert it. It is there. So when court is seized of the matter in a jurisdiction which practices absolute immunity, one looks at the defendant. The defendant is a foreign state. The court itself should, like in arbitration, we just have to be satisfied prima facie that we have jurisdiction. The court should raise the point, you are a state. Prima facie, you have sovereign immunity. Are you submitting to my jurisdiction and therefore waiving it? So that's the very difference. But in crown immunity, our proposition, which the court ultimately accepts, is that it has to be asserted by the crown. In other words, it does not me, a state-owned enterprise, say, I am the government, therefore please give me immunity. It has to be the government who say, you are part of me, please court give it immunity. So the assertion has to come from the crown. Now, in the case of the TNB case, the crown immunity was asserted by the legal in-house counsel of China National Court. He said, I am entitled to it because I'm part of the government, etc., etc. It doesn't come from anyone beyond the in-house legal counsel. So we say that is clearly not adequate. The court then also looked at a number of things. First, they looked at law. They looked at Article 85 and 86 of the Chinese constitutional law and say that on the face of it, just by looking at what is defined as the government, a state-owned enterprise clearly is not. It doesn't fall within because there's a list of what are part of the CPG. So that is one way to look at it. Another way, the court then looked at how the state-owned enterprise is set up. She refers to the company law, which provides that the state-owned enterprise is a separate legal entity under company law, and he also referred to the state-owned assets in enterprises law in China. That's an important law that deals with it. And under Article 6, it merely states that the government is the contributor of assets to the state-owned enterprise. It doesn't say that it is controlling it, nothing of the sort. So the court say, therefore, you, Mr. So-and-so, who is the in-house counsel, would not be entitled to assert crown immunity or immunity per se. More to it, and I think this is the killer point, very important as well, because it is a position of the Central People's Government. They provided a letter at the invitation of the Secretary of Justice, which actually and I will read that out. It's in the judgment, but it's very important. They actually say that China National Co. is a wholly state-owned enterprise, an enterprise legal person established according to the law. According to the relevant law, legal regulations of our country, that's China, a state-owned enterprise is an independent legal entity which carries out activities of production and operation on its own, independently assumes legal liabilities. That's why enforcement, you go to the state-owned enterprise assets, and there is no special legal person status or legal interests superior to other enterprises. Now, I think that is so very clear, and so, if I may say so, right, by looking at the relevant law. Therefore, and I jumped, there are some exceptions like when you are doing certain activities which would amount to act of state, then you might fall within the iure impere situation. So therefore, the letter continued to say, save for extremely extraordinary circumstances where the conduct was performed on behalf of the state via appropriate authorization, etc. So this is the sort of the only gap that in future anyone who wants to argue may play around with. The state-owned enterprise of our country, that is of China, when carrying out commercial activities shall not be deemed as a part of the central government and shall not be deemed as a body performing functions on behalf of the central government. And that, I think, really puts the matter of state-owned enterprises status to rest. The court, however, goes one step further and say, right, in case I'm wrong in here, and I'm very glad she did it, because I don't want to just rely on a statement. I want law to support the conclusion, which is what I've sort of done when I propounded our opinion onto the web. The court say, in case I'm wrong, let us look at how Crown immunity is to be ascribed. I read to you the two passages, Crown extended to body corporate, subject to the question of control. So the court say, I will then look at the question of control, because this is a common law jurisdiction, common law test of control, and it is the control test that I will apply. And when you are applying the control test, we've submitted to the court a number of factors to be taken into account: financial management, personnel, and how you can deal with your assets as an investor, etc., and it's set out in the judgment. And the court then say, when I look at the common law test of control, this is the conflicts of laws rules coming in, I have to decide how I am to look at that control. And that control will have to be looked at by reference to the law of the place of incorporation, the lex incorporatione, and therefore PLC law. So PLC law was called upon, this is how we argued, and that's why PLC law was called upon to deal with the setting up de jure, not de facto, de jure setting up of a state-owned enterprise. And there is a section in the company's, first of all, as I said, the Article 3 of the company law say clearly that they are independent, they can deal with their assets once you're set up under the company law. State-owned enterprises are set up under the company law. There is a chapter in the company law that deals with state-owned enterprises, how CIArb, which I have to give you the full name, why in Chinese, it's a very long State
Asset Supervision and Administration Commission.
Thank you. CIArb, and CIArb only acts as like a shareholder. It doesn't direct how the state-owned enterprise is to be operating, and so therefore the CIArb is no different from any other investors or shareholders. Then the asset law, the state-owned assets in enterprises law, that particular law also provides explicitly that the State Council shall, according to the law, perform the contributor's functions based on the principles of, and this is a very important principle, in Chinese, in short term, it's called 政企分开, 政府 and 企业, government enterprises separation. And it is actually in the law the principles of separation of government bodies and enterprises, separation of the administrative functions of public affairs and the functions of state-owned assets contributor. So as a government, you have a public affair administrative function, but that is separate from the state-owned asset contributor. And non-intervention in the legitimate and independent business operations of enterprises. So that makes it very clear. That particular principle was something that the judge really rely on. So, and there are other provisions as well. You can read that in the judgment. So one can see that once you have the state-owned enterprise that is set up in the normal way, the legal principles will allow you to establish that it is not part of the government. This court judgment will reinforce that analysis before another court, for example, and therefore, if it is not part of the government, it is not easy for them to immediately say, I am enjoying state immunity. I'm not saying they cannot. I'm not saying that they will never enjoy, because there could be situations where it could be triggered, because they do perform certain act of state type of functions, I think, at times. So there is that important decision here that I think will shed light on the very factors as to whether a state-owned enterprise enjoys Crown immunity, and the reason they don't enjoy is because they are not part of the state. And if on that basis one can argue they therefore do not also enjoy state immunity per se. Now that is, again, my advice, my analysis, subject to, as I already said, there's always some exceptions, because the function test may sometimes come in. There's a control, and the function test is always an evaluative mix. So I come to the last point I want to make, and that is, what is PRC's, what is the state government position on that? We've actually brought that to the attention of the judge, both in the Hua Tianlong case and as well as in the China Co case, because we provide all the information we need to in order for the parties to, or for the court to properly deal with it. There are three statements that are of particular relevance. One is the letter that was given by the Hong Kong and Macau Affairs Office, which is quoted in the TNB case. The second, and that of course is written to the courts in Hong Kong, so it may be said that, oh, it's a very limited, specific type of situation. But there are two other statements that I think are of importance. One is Guang Jin's statement as the Ministry of Foreign Affairs, dated 16th of November, year 2000, to the UN in a meeting on the Convention on Jurisdictional Immunities of States and Property. This is the convention I said has been concluded, but not enough states have ratified it to make it coming into force. China has signed it, but because it is not yet in force. In that particular statement, he said this, and this is to the UN, so this is an open statement. That's why I got it. It's not that I get any state secrets. If you Google hard enough, you will find these. Yeah, I found these by Googling hard enough, all right? Under Chinese law, state enterprises had independent ownership of and the right to dispose of their own assets. That's actually enshrined in the assets law and the company law. They were thus independent of each other, China National Coal or China Rail, and of the states. Nothing to do with the Central People's Government. The draft articles, which are the articles that are being looked at in the convention, the UN convention, objectively reflected that independent relationship between the states and state enterprises without creating any additional privileges for either, and should therefore be retained. So it's a clear statement, in my view, that was made to the UN in a meeting. The next statement was also made by the Ministry of Foreign Affairs in October 2003. In this particular statement, the Ministry of Foreign Affairs said this, the context of which it was made, I have to say, is not entirely clear, so I don't want to proffer a view that may not be accurate. The MFA's statement was this: with regard to the relationship between a state and a state enterprise, the Chinese delegation maintained that in principle, and note the words in principle, you know, as lawyers we always look at the gaps, okay, in principle, so there may be exceptions. A state enterprise or other entity set up by a state should not enjoy state immunities, so long as the state enterprise or the other entity has independent act and the capacity to sue or be sued and has the capacity to acquire, possess, or own or dispose property, including the property they operate and manage authorized by the states. So, autonomy. You can see that actually China is using the test of control, albeit not codified in a particular, albeit not referring to the test of control, but all the elements are very much the common law test of control set out in the case of Katrina, which actually were referred to again in the judgments in the TNB case. So these two statements give rise to at least an argument or an understanding that state-owned enterprise do not per se enjoy state immunity. At least in principle they do not. But as I said, there's always some special acts that they are carrying out which might be act of state, and then by reason of that they may still therefore claim that they are not in this type of situation, but in the situation of acting as a part of the state and therefore enjoy immunity. So I think these two cases and these three statements, I hope, make the position clear about state-owned enterprises and Shiye Danwei, Crown immunity and state immunity. Now, why that is particularly important, I think from a business angle, and also from China's point of view. Now, I don't speak for China. I hasten to add. I don't speak for the Hong Kong government. I speak only for myself. Is that in the light of this Belt and Road Initiative that is being promulgated, this initiative is, in my view, a very good initiative because more people would have better infrastructure, would have cleaner water, would have energy, etc. But this initiative involves a lot of state-owned enterprises. A lot of them are going outbound investment into various states. If these outbound investments are always subject to immunity, it would cause a lot of concern when we go into PPP. So this P, the private, is the Chinese state-owned enterprise. The P is the relevant government, the whole state government, and then the partnership. And therefore, the clarification, in my view, of the China National Court judgment that has come out actually is a good thing also for the outbound investment policy for China, because they have to let people know that they will not invest, and then every time they breach a contract and being sued with an arbitral award, they plead state immunity whenever that is being sought after. And I think these type of arrangements and these latest developments will hopefully help to clear some of the myths that have been done. I'm not going into the other confusion that people have talked about in the FG Hemisphere and DRC case, which is a sovereign immunity case, nothing to do with state-owned enterprises, but because it was done at the same time of the Hua Tianlong, people got that mixed up and sort of write everything together as in one judgment, again with the greatest respect to those who try and sort of portray whatever impact there was. They were clearly wrong. So I think I would stop here and be very happy to try and answer questions, if any. I may not have an answer. So thank you very much, Dato.
Thank you. I'm sure when you saw the title of this talk, you had doubts where we were or heading to or what we are going to hear about. But now, in the context of this One Belt, One Road, push by PRC, and also in the context of our own government, preferring to have Chinese investments in Malaysia. This decision and this distinction of the type of enterprises that are in China is of importance. And I'm sure there are a lot of gems that has been shared with us by Ms. Cheng on these issues. But I'm sure you also have some doubts. And so I'm going to open the floor to questions. It would be good if you can stand up, identify yourself, and then put forward your question. Now, maybe I should start the ball rolling by asking a question. Now, say, for example, a private Malaysian incorporated company wants to enter into a contract. How can they, with a state-owned enterprise, not of the kind that you said is controlled or the assets are... yes, that's right. Yeah. What should we look out for, or what should we provide in that contract to safeguard our position? Free advice.
A very broad question. I guess in terms of immunities, in case it is to be raised, people would always advise to put in a clause that immunity is being waived. The effect of such a waiver depends on the law in which the particular clause is being looked at. The English decisions say that a waiver in contract is not adequate. It has to be waived in front of the national court. So in the English common law situation, that may not be adequate, but there are other places who will accept that type of waiver. The second suggestion, which goes back to where we are here, that you must put in an arbitration clause, because questions of immunity, state immunity, does not arise in arbitration, because go back to the concept of state immunity. People don't sometimes overlook it. State immunity arises insofar as National Court of State A does not have jurisdiction over any other state. But it has nothing to do with State A agreeing to arbitrate. So with an arbitration clause, you can properly have your dispute resolved with any state-owned enterprise, or indeed with the government. So let's say I use China Rail, for example, as an example. China Rail and the Malaysian Railway Board minister enter into a contract. By way of arbitration, neither of the parties will say, no, you cannot arbitrate, you don't have jurisdiction, because the question of state immunity does not even arise, even in the context of clearly the Malaysian government is, of course, a state, as it were. So I think arbitration and then put in waiver clauses, I think would always be good.
This involved assets of the Chinese-owned enterprise in Hong Kong. Would the same position be the case if the assets are in PRC itself? It's an enforcement of an arbitral award.
Right. Now, I do not know PRC law enough to answer that particular question. The assets in Hong Kong are not... Sorry,
we have the Hong Kong court
to say that state-owned enterprise do not enjoy Crown immunity. Now, I do not know whether in mainland China they have concepts of quote-unquote Crown immunity. In other words, I do not know whether it can be said that in PRC courts does not have jurisdiction over the Minister of Transportation, right? I mean,
yes.
State-owned enterprises, I think, are well settled.
Yes.
I think there are many cases that involve state-owned enterprises. In fact, before the TNB case, there are many cases in Hong Kong where state-owned enterprises have been sued, or they have sued, and no one has thought of raised it, because I think it's well understood. So I was very glad that China National Co. raised it, because it allowed me to put the law right and put all the myth about the Hua Tianlong case to bed. So I think insofar as state-owned enterprises assets is concerned, I do not think, and it's only my feeling here, which I should not be uttering as a lawyer, will have a problem.
But that's a policy. The three statements that you were referring to does indicate a certain line, a policy, as far as the PRC government.
Exactly. And so, and again, as I said, there are many cases, as I know, in China, in mainland China, whereby the state-owned enterprises have been sued, and their assets have, you know, been subject to whatever order that has been made. So I think it would arise in state-owned enterprises in China, but when it's relating to the governments, I cannot be sure because I do not know whether
Okay. No, I've exhausted my 3 questions, so it's yours now. The floor. Any questions from the floor, please? Yes, please.
Ernest Azad, thank you very much, Teresa, for the insight into the large number of corporations that are coming around to Malaysia to do business. Now, state-owned enterprises, so we are quite clear on those because they are already, you have clarified on that issue. But are the corporations that have contracts overseas, say with Malaysian companies, are they all state-owned enterprise? Do you have the other one?
they call public institutions.
Yeah, public institution. Yeah.
I don't know. I do not know, and that's part of the due diligence. I think anyone would have to do in order to deal with it. So, if you happen to be contracting with a 事业单位, a public institution, if you're contracting with a public institution, then you will have to check all the, you know, to make sure that it is a 事业单位, in which case you will then have to put down certain waiver points, waiver clauses, even though in the English court it may not apply, but in other places that may amount to a waiver of some sort. So that's why the distinction become important when you are structuring your contract.
Yes. Thank you.
Yes, Teresa, I think it's been a very interesting talk just now. What I'm unsure, and this is what, based on what I've heard in a recent seminar here in May, as to arbitration, because this One Belt, or rather One Road, One Belt initiative is fast coming. But if arbitration is going to be the solution, it was told that for arbitration awards to be enforced in PRC, it must be done through an institution recognized by the PRC. So is that true?
No. Oh, so you mean arbitration in PRC?
Because the One Belt, One Road eventually would involve probably disputes between the host and Chinese entity.
Where is the seat of the arbitration?
Perhaps if it's in Malaysia?
Okay, then absolutely no problem.
Even in PRC?
That I can, I mean, unless the court is wrong, all right? But if you ask the Supreme Court, who will look at and refusal to enforce award, it is very clear that everything else being equal, you know, it's valid and blah, 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 no procedural problems. The PRC court will recognize the award that is rendered in, for example, KLRCA, as being an award under the New York Convention for it to be enforced, because the seat is in Kuala Lumpur, Malaysia, New York Convention, China, New York Convention, so you can enforce it in that way. The confusion is because one is looking at the arbitration in China. If it is arbitration, let us say, in Shanghai, let me take an example. The matter is submitted, or in the event of any disputes arising out of this contract, the dispute shall be submitted to KLRCA for arbitration in Shanghai, for example. That would be a problem, because KLRCA is not, I think, I'm not a PRC lawyer, but I think I dealt enough with the enforcement situations in China to give a view. The KLRCA is not an arbitral institution recognized under Article 10 of the Chinese Arbitration Act, and therefore under the Chinese arbitration law, I think Article 16, either 10 or 16, I can't remember the number, it has to be arbitration in Shanghai by a recognized arbitral institution. So that could be problematic. That could be problematic.
So the solution is not to put an arbitration clause where the arbitration is in China then?
Well, the solution is to use, for example, first you choose if you want to arbitrate. For example, you want to arbitrate in Shanghai. So what rules, what institution do you choose? You will probably have to choose CIArb, Shanghai International Arbitration Center, or whatever arbitration center that is recognized within the regime of Chinese Arbitration Act. Because we always say you look at the validity of the arbitration clause, and when we look at that and we start with the conflict of laws rules, you see whether there is a governing law. The governing law usually also governs the validity of the arbitration agreement. Alternatively, you look at the law of the seat to govern the validity of the arbitration agreement. And a lot of the times it's PRC law. And that is why, I'm not trying to do an advert here, but I was the former chairman of HKIAC, and during my time, we promulgated a model arbitration clause to say, to ask the parties to write down the applicable law that governs the validity of the arbitration agreement. So if you make that, let's say you say the law governing the validity of this arbitration agreement shall be Malaysian law. Malaysia does not have the limits on KLRCA, Shanghai, etc. That clause would be valid in Malaysia, for instance, I think. I'm not a Malaysian lawyer. Then the validity of the clause would be upheld. And then when you come to enforce it under the New York Convention, the New York Convention say the arbitration agreement under Article 5 is either the law agreed to by the parties, the law designated by the parties, so you have designated a law that makes it valid, alternatively the law of the seats, which is Shanghai. So if you leave it to the Shanghai law, when it comes to enforce, even if you push ahead with your arbitration and say, I find these being a valid arbitration agreement, when it comes to enforcement, the law of the seat will still say, I'm sorry.
Thank you.
Yeah, just actually a follow-up from what the judge had. I had a different question, but I have a follow-up from what the judge just asked. The point you made about KLRCA and Shanghai, is that only valid where the seat is in Shanghai? So if the seat was Kuala Lumpur, but the hearings were held in Shanghai, would that point still be applicable?
Very good question, and that's exactly what I think we should, or people should do. If you want for the convenience of the parties, you want the hearing to be conducted in Shanghai. And you want to write it in your arbitration clause, but you want the seat to be in Malaysia so that the clause is valid. Then you want to say KLRCA arbitration in Kuala Lumpur, in Malaysia, with the place of hearing to be in Shanghai. So the seat is clear. You also, by agreement, dictated where you're holding the hearing. The whole thing would work.
So it's only where the seat is moved from a different venue.
Yeah, if you say KLRCA arbitration in Shanghai, the seat is Shanghai, Shanghai arbitration law apply. If the arbitration agreement is something else, you might have other arguments, but usually it's PRC law. Then you have PRC law governing the arbitration agreement. Alternatively, the law of the seat, Shanghai, governing the arbitration agreement. Arbitration Act in China say it is invalid. So you would, if you want to have the hearing in Shanghai, my advice would be to write the clause in this way. So KLRCA with the seat in Malaysia, KLRCA arbitration in Malaysia with the place of hearing in Shanghai. Then it's very clear. I think no court would invalidate it.
You wanted to ask a question? Yes, please.
Hi, I'm Lim Sewei from Malaysia Moderator. I'm just wondering if you have In the case where you have an arbitration clause of a public institution, would that give rise to an issue of arbitrability? An issue of arbitrability. An arbitration clause with a public institution, for instance.
State-owned enterprise.
No,
Yeah, I'm wondering something along the logic of Baxter Industries, for instance, where competition law questions, the logic behind why competition law questions at one point in time in the US couldn't be arbitrated because it had a wide-ranging domino effect in terms of economic implications on the populace as a whole.
that question will probably have to be answered by reference to the law that you are looking at. Insofar as just looking at it in the abstract, where you have a private company and a 事业单位, which is the public institution situation you're talking about, entering into a contract with arbitration usually on a commercial transaction, because they are allowed to do certain commercial transactions, albeit still controlled by the government. That would not, I think, prima facie be any problem, because governments entered into arbitration agreement. So a limb of the government entering into arbitration agreement would not give rise to any issue whatsoever that people have been successfully raised, that I am aware of, but I'm not all-knowing. But so I would say that probably would not be a problem. You then mentioned about competition law and arbitrability. It will depend on the place of arbitration, how they look at the question of arbitrability. And as I said, I am not aware of any laws of any place that say a government or an arm of the government cannot enter into an arbitration agreement. But I may be wrong.
Hi, I'm Ricky. Can I ask, just in China, preservation order in arbitration can be only issued by the courts in China. Can that court order be enforced in Malaysia?
As a Malaysian?
Yes,
this is a Malaysian law. Dato and Judge Lim here can answer that.
Yes.
I think I sense that you heard there was some commentary yesterday over the radio over a preservation or a stay order given in China against wife and the child coming back to Malaysia. I'm afraid I can't comment on that because reciprocal enforcement of judgment, the question will be whether it can cover such preservation orders or not. I need to do more research on it.
That's not the. That case was because she was prevented to leave the country because she was blacklisted. That's another issue. My question is, an international arbitration in China, handled by CIArb or whatever, but that institution cannot order prohibit or you need to go to the Chinese court to get a so-called injunction for preservation of order for property assets. Yeah, with that court granted order by Chinese courts. Yes. Unlike Malaysia, the arbitrator itself or the tribunal can give such an order or interim award, and it can be awards in New York Convention. New York Convention country, yes. Okay.
If it is an injunction, an interim injunction, you cannot rely on New York Convention. New York Convention only covers award that finally dispose of a particular issue in dispute. But interim injunctions may be enforced if you, for example, in Hong Kong, we have adopted the 2006 model law. Then that can be enforced in other model law countries that adopts also that particular law. So, may I correct that first?
Yes.
Actually, the question I wanted to ask before I got sidetracked. I'm just curious, why was this even an issue, this case? Because I'm just reading in the judgment, in the middle of paragraph 15, the judge says, there is no concept of crown or sovereign immunity under PRC law. That is accepted. So if there is no concept of sovereign or crown immunity under the law of the country of incorporation, or the place of incorporation of this SOE, why was it an issue in Hong Kong in the place of enforcement?
Because this is the one country, two system. Hong Kong practices common law quite separate from whatever is happening in the mainland law. So under the common law, crime immunity is a common law concept. So under the common law system, as I said, before 1997 continues to post 1997, a crown, a central government, and in our case, would be entitled to plead immunity, crown immunity. So on that basis, one has to look at it, whether it is entitled to plead it. Then you look at the place, and then in the common law test, the common law test would not look at whether or not at the place of incorporation it has or not has anything of the same sort. You bear in mind how crown immunity began under English law. It is the same legal system, right?
That's why I can understand the sovereign immunity point. I'm just curious why the crown immunity point was the issue. I could understand the sovereign immunity point being raised whether or not there was sovereign immunity. I'm curious why, but the issue in this case wasn't sovereign immunity.
This case is crown immunity. Sovereign immunity, I don't understand why you think there's a distinction. Here is crown immunity, and it's entirely because of the one country, two systems. So as I said, before 1997, under the same legal system, crown immunity exists in England, of course, and therefore the same in Hong Kong, and so it becomes part of the common law. The exception is created by the Crown Proceedings Act and the Crown Proceedings Ordinance in Hong Kong. And so that common law concept continues. And that common law concept comes to be applied to Hong Kong. So when it comes to look at in Hong Kong and looking at the Central People's Government, it doesn't matter whether they have it or not, but you apply the common law concept and you look at the question of control. First, you look at whether it is the Crown. Secondly, whether the Crown asserts immunity. And thirdly, whether there is control, and even going through that. And the control is a common law test, irrespective of what mainland China's law says on whether or not there is Crown immunity.
I'm still a bit...
Sorry,
okay.
I'm still understanding. But you have a situation where the Crown itself, in this particular case, or the central government, does not recognize Crown immunity. It does not assert Crown immunity because it doesn't even recognize the concept. So why is the Hong Kong court then considering this issue when the government itself, the Crown in question, which is not the Hong Kong state government, but the KLRCA government, saying I don't even believe in Crown immunity.
But this isn't quite the point that was explored, and that is why someone asked the question. I said I do not know whether in China they have it or not. This is not pursued when it's. I don't think paragraph 15 is a statement of law that one can quote as having been considered. It was not sort of considered. It was looking purely at common law here in Hong Kong. What do you do when your crown is being alleging, or someone is alleging I am entitled to crown immunity? So, yes, it was raised. That's right. So it's not
enforcement. It was raised.
yes. They tried everything. I'm sure anyone to resist enforcement.
I think we have time for one more question from the floor. Maybe I should ask the last question as well. This is out of pure ignorance. So if I'm wrong, please excuse me. The structure of the court system in Hong Kong, this is a decision of the court of first instance. Is there possibilities of appeal? And if appeal, is it only, where does it end?
If it goes to appeal, it will go to the Court of Appeal, and then it will go to the Court of Final Appeal, and that's it.
That's in Hong Kong.
In Hong Kong itself. And this is the one country, two system very clearly. The Chinese courts cannot rule our cases. We rule our own cases.
I just wanted to okay. Ladies and gentlemen, I think we had a very fruitful almost 2 hours here. And thank you all for being attentive, for participating. But above all, I think we are most thankful to Ms. Teresa Cheng for sharing her insights, experiences, and also for telling us what to look out for, as many people are getting into this initiatives of One Belt, One Road, and also our government is very inclined to give more contracts to Chinese parties. Okay, with that, let's do the usual way. Thank Ms. Teresa Cheng for contributing.